This is the webinar with the luncheon interview with the US Patent Commissioner. For the record, since we're recording this and for later viewing on the internet, for the record, we'll say that this is April 26, 2018. This is the luncheon webinar at Ackerman LLP in our Washington office. Ackerman's a general practice, diversified law firm. We have over 700 lawyers in 24 offices. And we have a substantial IP group, which is why we're interested in this. I'm Stephen Glazier. I'm a partner here. Our speaker today is, as you know, the US Patent Commissioner, Andrew Hirshfeld. He has been at the Patent Office since 1994, where he started as a patent examiner. He's done a variety of jobs in the Patent Office. And he became a supervisory patent examiner and later served in other roles, including he was Group Director of the Technology Center 2100 for Computer Architecture and Software. He became the Patent Commissioner in 2015 and is in effect in that role. He's the Chief Operating Officer of the US Patent Office, who's intimately involved in the operations and executions at the Patent Office. He has a BS from the University of Vermont and a JD from the Western New England College School of Law. So he's a lawyer and an engineer and a very experienced Patent Office official, so he's a great person to listen to. I will give you the podium here, and he's going to make opening remarks on current developments at the Patent Office of interest. And then we will go into a Q&A question and answer session where we're going to run over some questions that we have gotten in advance from the audience on topics today in the patent community.
Okay. Thank you very much. I very much appreciate you having me here. I'm looking forward to our discussion today. What I will do, as you just heard Stephen say, is I'll give some opening remarks, but I'd like to keep what I say brief so we can get to questions. I know a number of questions were submitted in advance. I'd like to spend the bulk of the time discussing those. Let me start by saying we have a new boss at the USPTO, Director of the USPTO and Undersecretary of Commerce, Andre Iancu, has been in position for just over 2 months now, about 2.5 months, and it has been an absolute pleasure to work with him. And what I'd like to do is outline some of his vision and the things that he is focused on, and then I'll get into a little bit of a PTO at a glance, and then I will we'll turn it back over just so we can start the questions and answers. Let me start by saying that Andre Iancu really has two main sort of foundational areas of particular focus. One of those is making sure that we all involved in the patent space are having a very positive discussion and pro-IP, pro-patent discussion about all of patents and the issuance of patents. It's very important that we don't lose sight of and I'm going to use his exact words here, the brilliance of inventions, and you want to get it exactly right. The brilliance of inventions and the excitement of invention is a phrase that he recently used in a speech. And he's always constantly reminding all of us at the PTO and in the public to keep that in the forefront of our minds as we continue to go forward. He's really trying to change the dialogue on IP to a much more positive message. Now, that's certainly not to say there aren't challenges, there aren't issues that need to be addressed. We obviously, the patent prosecution is a very complex system. There will always be challenges, and there are challenges now, but we should not lose sight of the positive. And I think that's a wonderful message, and I can tell from my position as commissioner, as I meet people, I can really tell that that's having a positive impact. We really see that. Another area, a foundational area that he's very focused on, is how to interject as much certainty and reliability into the patent grant as possible. And in other words, when somebody gets a patent, we want to know that it's valid, that it's going to withstand challenges, that they can use that patent to make the right decisions on and minimize the concern that they have that patent would be overturned. And so we are very focused on what we can do at the office to help increase reliability and certainty in the patent grant. Obviously, the main role that I have is I oversee all the examiners, the patent examiners, and so that prosecution, very important to us to make sure that we're doing our job correctly and that we are proceeding with certainty and reliability. Some areas within that that he's particularly focused on are one, subject matter eligibility, and I'm sure we'll have further discussion about that shortly, but certainly we've recently issued a memo to examiners on a recent case, Berkheimer, that came out, and we are currently looking at all of the guidelines that we've issued to see what, if anything, can we do differently than we have in the past. We have more of a body of case law now, so we are taking a relook to see how can we add certainty and reliability. I think we could all recognize that there's been recent Supreme Court cases in the subject matter eligibility area. These certainly have added some confusion and some challenges, and so we're trying to redouble efforts to see what we can do to try to address that. Another area that he's focused in, particularly for me, since I oversee the examiners, is the examiner search and making sure that the best prior art is in front of the examiner, that when they're making patentability decisions, they're making the best decision, the most educated decision that they can make. So we're looking at a whole host of ways to enhance getting art in front of the examiner, ranging from potential use of artificial intelligence as a pre-search, so that an examiner, when they first get a case, even before they look at it and search it, there has been some search done in it, and it gives them a running start, so to speak, when they have the case, to anything we might be able to do operationally to increase the search. So that is another area that we're focused on. And while it's not in my direct purview at PTO, certainly Director Iancu is very focused on the PTAB, more particularly the AIA trials, where patents can be challenged. There has been a number of significant discussion about potential changes to the PTAB, what, if anything, should be done, and I know he's very focused in that particular area. While I'm discussing PTAB, I would be remiss if I didn't mention the 2 Supreme Court cases that came out this week. It's not often you have a week with 2 Supreme Court cases on patent law, but we did have two court cases earlier. One of those was oil states. That was a case dealing with whether or not these AIA trials were constitutional. The Supreme Court did hold 7-2 that they are constitutional. The other case was SAS or SAS, and that was dealing with the issue of whether the PTAB could have partial institutions. In other words, if there was a petition to challenge a certain number of claims that they can institute on less than what was in the or a subset of what was in the petition instead of all. What they have been doing is a by claim and by issue, and now it's all or none, and there was a 5-4 decision that the petition should really stand or fall together. Where we are with those is of course, with staff, there is going to take some changes that we need to make at PTO, and we are taking next steps for that, and making sure we're familiar with all the nuances of the decision and determining how to move forward. I'd like to mention that Chief Judge Rushke, he's the Chief Judge of the PTAB, he will be holding a webinar on Monday at noon that is open to anybody from the public, and he will be addressing these cases in more detail. If anybody has questions that you would like to submit to me, you can certainly email them to me, and I will make sure to forward them over to him so that they can be addressed potentially in the webinar, or at least PTAB is aware of some of the concerns or issues that people would like to bring up. So I'll transition a little bit to just give you a high-level overview of PTO, and then Stephen, we can get right to the questions and answers. But PTO at a glance, or at least the whole Patent and Trademark Office is about 13 people, 13,000 people, excuse me, within the patent. A little understated there. In the patents organization, which is what I oversee, we have about 10,000 of the 13,000 people. That includes 8,200, just over 8,200 patent examiners. So that is, of course, the bulk of the staff. To give a round number of the number of filings that we receive in a year, we have about 450,000 new cases being filed a year. These are not like requests for continuation cases. These would be just new cases. When you add in the request for continuations, you actually get about 600,000 cases that are filed per year. But new cases are about 450,000 a year. I've heard many people ask about filing rates, and there seems to be this feeling that filing rates are dropping off and people are not filing in the U.S., and that is really not an accurate statement. So right now for this fiscal year, we are about a 3% increase in the filings of new cases as compared to last year. That is actually a higher percentage increase than we were expecting. The last few years have been somewhere around a 1% increase compared to the previous year, so that the 3% is a much larger number. Doesn't sound like a lot, but when you do the math, it is a lot of cases that are being filed. Just historically, because again, I know people ask about this very often. Historically, in the last 20 years, we've only had 1 year where the filings, the amount of filings decreased, and that was 2009, obviously the financial crisis at that time. But all the other years have been an increase in filings from the previous year. Where people get confused is when we add in the request for continuation, and you have a total number. That number is decreasing, but we actually look at that as a good thing. Request for continued examination is rework of cases. We do want to minimize that, so it's actually good that those are dropping. But brand new cases have been increasing and increasing essentially every year for the last 20 years. So with that, I'm ready to just to dive into any of the questions.
Cool. You mentioned the rate of filing new cases. Do you have a feel offhand for how the split between U.S. origin and foreign origin is going? Is that
I don't have an exact percentage, but the majority of the filings are from U.S. applicants. So the increase is certainly, at least in major part, to the U.S. filers. Yeah, I contrast that with the trademark side, where trademarks is having bigger increases, but theirs primarily from, I think, the majority from China.
Really?
So a whole different issue, yes.
Okay, let's go to some of the questions that we got from the audience, and they're pretty interesting. The first one here is the PTO. Is the PTO working on new guidance for examination regarding Section 101 and patent-eligible subject matter with a goal to have a clear definition of abstract idea? Oops. There we go. Our screen. We got to wiggle our mouse once in a while. The screen goes dead. With an idea to establish a clear definition of abstract idea, directed to an abstract idea, and something more, which is famous undefined key terms in the Alice Mayo test from the Supreme Court. And if you're working on these guidances, when do you think you may have them published? You may have gave us some information on that.
Sure.
Remark.
Sure. I did give some. Let me just address what came out last week, and then I can address the question with more specificity. What came out last week was in response to a Federal Circuit case called Berkheimer, and I don't want to get too weedy on that, but basically held that the conclusion of whether additional elements in a claim, and it's really the step 2 in the Alice Mayo framework is conventional or well known, that's a question of fact, and that's not the way that the USPTO was treating that. So we did just recently come out with a memo to all examiners on this. We also, on the same time, came out with a Federal Register notice, which basically takes the language of the memo, puts it in the Federal Register notice, and then has a comment period for the public to provide us feedback. What we tried to do in this memo is to keep the goals that I articulated earlier of certainty and reliability in mind. So we were very clear on what steps an examiner can take and how they're going to evaluate this issue of well-known or conventionality, so that everybody is on the same playing field and understands how we're proceeding forward. And I'm looking forward to getting more input from people during the comment period, which is something we've done in the past comment period. And I think that will be very helpful. To the question, that memo does not address abstract ideas or the directive to, as was asked in the question. It is only one portion of subject matter eligibility. We are currently looking at our guidelines and considering these exact issues that are raised in the question. We certainly are working on the directed to, how can we make that more reliable and repeatable in an examiner's decision, so that there's less gray area than there is today. And we are also considering of whether we can, being consistent with all the case law, come up with a better or even a definition of an abstract idea. So these are all issues that we're considering. The question also asked time. Unfortunately, I don't have, I can't give you a time. I think that these are obviously challenging issues which we're working through. Depending on what we end up with, we could come out with them right away. We could decide to do a comment period before they go to examiners, or have them go to examiners and concurrently do a comment period. All kinds of ways forward, and these are the exact issues we're working on now. So suffice it to say, I can't share a time because I don't know the time yet, but we are very, that is on my plate, I think right now, right at the top of the things that I'm focused on with others at USP.
That'll be very popular when it comes around. Be a big hit. A question. Would you consider possibly a definition of directed to, that if the claims do not preempt all possible embodiments of the abstract idea, so that you could implement the abstract idea outside of the claims, that's not directed to the abstract idea, but to a more specific subset of it?
So preemption has been something that even the courts have written about. It's an approach that we've often discussed. So the short answer to the question is, of course, we're considering every path forward. Preemption is one of them. I will tell you that personally, every claim is preemptive to a certain degree. That's the intent of the claim. It's a very fine line of how you define preemption, so I think there's challenges there, but that's not to say it's not something that should be considered, and we are basically looking at everything and trying to take a fresh approach and say what can be done. So we are looking at preemption as well as any other approach we think will be helpful.
Great, great. Next question here. Will the PTO publish new guidance for claim construction for the office, perhaps to drop the BRI test, broadest reasonable interpretation, in favor of the Phillips versus AWH test used in the federal courts, which is often summarized as the ordinary and customary meaning, where primary use is made of intrinsic sources and extrinsic sources and expert testimony are viewed as only secondary?
This is an issue currently being discussed about whether the PTAB for their trials, whether they should be using the BRI standard or the Phillips standard. And I think right now it's in the discussion phases, and I'm hoping, relatively shortly in months we'll be out with the approach that we would like to take. As far as examination goes, this is the issue about changing to Phillips is really a non-issue for patent examination, so that's the examiner in the first instance. Our plan is definitely to continue with the broadest reasonable interpretation. The issue about Phillips arises at the PTAB for their trials. I know that's something that Andrei Iancu and David Rushke are considering right now. And fortunately, stay tuned and as their discussions continue.
Okay, so later this year we'll see probably something on that.
I don't know exact time.
Trying to pin you. Okay, let's try another question here. What are the average allowance rates? We're going to a whole new subject here. What are the average allowance rates for software-enabled applications in Tech Center 3600 versus the average allowance rates for software-enabled applications in other tech centers such as 2600 or 2100?
So we don't track allowance rates per se by software-enabled in that phrase. So what I can give you is approximate allowance rates. I can obviously get more detail, but just from my head, I can give you approximate allowance rates in the different technology centers. So in the business methods area, which we do track, even though they're part of a larger technology center, we do track them separately, and that will include some software-enabled and some not. They are somewhere around a 15% allowance rate, and the other overall at USPTO, let me even give that number, we're just over 50% allowance rate in cases. Again, the business methods is about a 15% allowance rate, and then in areas like 2600, which is dealing more with computer graphics and computer interfaces, they are, I believe, even higher than the average. I think they're about a 60% allowance rate.
Interesting. What is the process to assign a patent application to an art unit? Who does this? Is it done by software with keyword searches or by human readers or both?
My understanding, and I think we actually have a contractor in the room here who does this, so he can probably give more detail, but I think it's a combination of both. We have contractors who handle the initial classification. I believe some of that is done by machines and some of that is done by people, and it's something we're always evaluating to see how we can improve. If I may, I'll just go over the whole process.
Sure.
Right? So once a case gets its initial classification, it is sent over to that particular art area that handles that case. At the point of receipt, it's then looked at to see if it's in the right location, and if it's not, if it's in the right location, then they would obviously keep it and then assign it to an examiner when that time comes. If it's not in the right place, then it would be up to the receiving area to then start a transfer process to send it to a different location. Then there's even a third step. When the examiner gets into the case, he or she will look at it and they may say, this is not my case for whatever reasons, it should go someplace else. And they can also institute a transfer process. At that point, though, they really need to find somebody. They would need to talk to an examiner who they believe it is their case and have that discussion, and they will have to work it out where it should go. So that's the high level of the process.
Okay. A related question. if an application is allocated to an examiner with an allowance rate that's low, say 1%, in an art unit with a low allowance rate of single digits, how can the applicant get the application transferred to an examiner in art with an allowance rate closer to the PTO average? And can the art unit designation and the examiner designation be appealed by the applicant?
The answer is yes, right? You can question whether the case, file a petition to have it reconsidered whether the case is in the right area. I will tell you that not all the time, of course, but most of the time I believe those petitions are not fruitful because we do take great care to make sure that the right case gets to the right examiner who handles that technology. The premise behind the question I'd like to address a little bit because I hear very often, and I don't know from you reading the question, Stephen, but I hear very often that people believe that different areas of the office should all have the same allowance rates or should all be at the average, right? If our average is, just over 50, then everybody should be that way. And really what controls the destination of the case is really the subject matter of the case itself. And then what's going to control the allowability of the case is also that subject matter. So if you're in an area, let's say if you're in the financial area of business methods, which the Supreme Court has spoken on as being a difficult place for eligibility, those examiners are going to have a very low allowance rate as opposed to if you're in, say, to use the example that came up before, 2600, where there's computer graphics and more technology-based type of inventions as compared to business methods, they will have higher allowance rates. So it's the premise that a case can just go to a different examiner is something I don't agree with because it has to be an examiner who is versed in that particular technology and that art, not just anybody from any place.
Do you find it is a clear dividing line or a gray area dividing applications between, say, business methods and software technology?
I do. I think that there are areas of overlap. I think there is gray area. What is software? What is a business method? When is something considered technological, for example? And what we do when we classify cases is we try to get to the bottom and best align it. Now, while there's gray areas, when you look at the subject matter of, say, business methods versus either the subject matter 2100, computer architecture, 2600, or any of the other TCs, as a whole, they're very, very different. There are going to be subsets where there's more similarities. Of course there are, but certainly to look at allowance rates overall and say this TC has one allowance rate, so it's doing a better or worse job than this other TC is just on a premise that I don't agree with. What we do at USPTO is we do look for analyses of everybody's works that they do, right? So what we do is we have statistical analysis of examiners, and we know, who's allowing, we can look at anything. Are you allowing on the first action more than your peers? Are you allowing, more second office action non-finals? We can track everything and look at that. Where we have areas of overlap, we do look and evaluate consistency and make sure examiners are being consistent. But again, to look at two technology centers is far different from looking at two particular sub-areas that might be similar. I also have very often had people tell me, hey, these two cases are the same, and they went to different technology centers. One allowed them and one rejected them, and when we dive into it, we see, no, they really were actually very different. And that's why they went to different technology centers, because the subject matter was very different in the way it was claimed.
Does a lot of that go to the claims as they're drafted?
Oh, it does. Yes.
The claim is the name of the game.
Yeah, you're actually asking a confusing question because right now we're in the middle of two different classification systems, but in the U.S. classification system, it's all about the claim, and an updated classification, and the spec is involved also. There's never an easy answer to that one.
I can't catch you. Okay, another question here. Again, this is a group of questions, related themes. We get a lot of this kind of stuff. We filtered out some of the redundant ones. This question's interesting. Is it a failure of due process for an application to be assigned to an art unit with an allowance rate of less than 10%, since rejection is essentially determined prior to examination on the merits? And two, where the application may have a chance of success that's closer to the average at the patent office if assigned to an average art unit with overlapping subject matter.
To repeat a little bit of what I said earlier, the subject matter of the case determines where it goes.
Right.
So, and it also will be the determining factor in whether or not it's allowable. So, the whole idea, if we were to take a case that wasn't allowable or is allowable in one technology center, is that it would be handled the same way in another technology center. I think when people are comparing different technology centers and looking at allowance rates, to me they're drawing a conclusion that's on somewhat faulty premise, that all the subject matter is the same, and that's really not true. So the case has to go to the place that it can be examined best where it fits best based on its subject matter. So I personally don't see any concern about that. Again, if you're in a financial area of business methods, it's going to be the same group of people who are going to examine those cases, and there's likely going to be a very low allowance rate as compared to other areas. Just to give one example.
So in a case law context with Alice, that certainly has a differential impact in different technologies. That then you would expect the result would be that different art units and different technology centers would have a differential impact, because Alice will affect some and not others at all.
That's correct. And what we do is we will look at all the examiners within any art unit and compare all of their statistics to their similarly situated colleagues. So we can see in an art unit if anybody's an outlier. So so let's take, if you had an art unit with everyone had a 50% allowance rate, and one person has a 20 or one person has an 80, right? They obviously are an outlier. Now the question is, why are they an outlier? Is that a good thing or a bad thing? We don't know. But what we'll do is we'll identify them as an outlier, and then we'll look at their cases and say, are you doing something better or worse? Are you doing something different? Do we need to have training? So that's the approach we take. But again, comparing to technology center to technology center is a challenge. But looking within pockets of similar areas is really where we can get the best comparison between examples.
Right. Historically, if you have an outlier, what's the result? Training, or
so it could take.
He trains you, or do you train him?
Well, you're right. It could be either, because an outlier doesn't necessarily mean bad work. It just means different work, and that different can be good or bad. So we'll take a look at that. If we were to determine that an outlier has best practices, and that does happen, and I'll give you one example. Sometimes we see somebody as an outlier, and they're an outlier because their allowance rate is higher than others. And when we look at their work, they're much more proactive than others about seeking allowable subject matter, making suggestions, getting on the phone and calling. And to me, that's best practices, and that's something we would certainly want others to use as well. On the flip side, if we see that somebody is rejecting things that shouldn't be rejecting, or never reaching out to the applicant, or we can address that through training. It really depends on what you find, right? So if you find, say, practices which aren't great but aren't wrong, right? That's a different issue. That's coaching and mentoring. If you find things that are wrong, it's coaching and mentoring and training, and maybe evaluation of more work to make sure that we have a good handle on what that person is doing. We really use that as an indicator. Yeah. We also make all these stats available to every examiner, so they can look at these stats and know how they compare to their colleagues.
You don't follow. You say you don't follow allowance rate. Do you follow the number of patents that are allowed by examiner, like monthly or quarterly?
We do. So we don't. I'm not so sure we said we don't follow allowance rates, right? So we do look at allowance rates, but we don't have goals for allowance rate. We don't say that any examiner should or shouldn't allow something. We don't say that as an office we want a certain allowance rate. We let that just be a result of normal examination. What we do look at is if somebody is an outlier responsive to their similarly situated peers. And that could be based on anything, allowance rates, the number of actions, you name it, we can track it. For those of you familiar with pair, anything that's in pair, we can track and monitor that.
Do you look at the number of appeals or the number of reversals on an appeal for an examiner?
We do. It's not as fruitful as we all would hope. Most examiners, when you do the math of the number of appeals and the number of examiners, most examiners will have, one or two appeals cases a year. And then when the PTAB gets to that case and decides it, it's years after the fact. And so take even subject matter eligibility, the laws have changed very often. So we do look at reversals and affirmances and use that information for what it teaches us. Oftentimes, however, the teaching is not fruitful or out of date, but we look at that because there might be good gems in there that will help us feedback and improve what the examiner does. What we also look at is things like how often do you go to, say, pre-appeal, right? And because that's more timely than the whole appeal process. So you can look at pre-appeal conferences and do you have an examiner that always reopens after pre-appeal or always allows after pre-appeal and that doesn't go to the PTAB or not, and look at all those type of things to see, again, how are you compared to your peers.
Okay, well, next question, which I think we touched on in answering a previous one, but I'll go ahead and throw it out here in case you have anything else to say. When an application's art unit is changed after the official filing receipt, but before the first office action, what process or criteria people are involved in this change? That's your 3 steps.
Sure, that would get right to the 3 steps. So that could have been from the examiner when they looked at the case, and as they got into it, they thought, okay, this isn't mine, and they found somebody that was a better fit for that application. So anyway, any part of the 3 process.
So will the art unit on the official filing receipt be the art unit that the classification contractors develop, or has it gone through step 2 with the first examiner?
No, I believe, and I will tell you I'm not 100% sure about this, but I believe that the art unit from the initial classification is what goes on the filing receipt.
Right.
Because that all happens very quickly in time, and so that you wouldn't have the time to bring in the rest of the process. But
right. Okay, this another question that's interesting. I think you touched on this. Are some art units in Tech Center 3600 instructed by PTO management to reject most applications of the grounds Section 101 and Alice?
Nobody is instructed to reject, cases unless somebody, has made the determination to look at a claim and say that should be rejected, right? So there's no as a matter of fact, what we are doing is the opposite, particularly in the business methods area, where we've been spending a lot of focus on trying to have examiners be more proactive in finding eligible and allowable subject matter, so that if they believe that the claims as written are not patentable, but there's patentable subject matter in the case, that they'll be more proactive and reach out. So we try to do the opposite, to try to foster the allowance of cases, but certainly we do not instruct that blanket rejection should take place, and nor do we shoot towards any allowance rate.
I think that's a great process. I think all applicants love to get a call from the examiner.
I'm a huge fan of interviews. I always say, in real estate, it's location, 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 and patent prosecution should be interview, interview, interview. I'm a huge fan of getting together with the attorney or agent and potentially the inventor, of course up to whoever's representing that person, with the examiner and having that discussion. I will tell you, I've seen this process from all sides, including many years as an examiner and a first-line supervisor, and now in my current role and previous roles, I get to talk to a lot of people. Very often there's disagreement where if folks involved would just sit down together, they can figure something out or realize why they disagree and really see how to move forward in a productive way. So to me, I would be pushing interview practice as much as we can. I also like to push video conferencing, because I think it's sort of the untapped world that we can explore right now. Primarily, all of our interview requests are coming in for telephonic interviews. If you interview over video conferencing, you can see the examiner. You can amend documents right in real time. You can share documents. We even have staff on hand to help from a technological standpoint, not only the examiner, but any practitioners want. Every technology center has somebody that you can call and say, hey, I can't connect. How do I connect?
Great. What platforms do you use for video conferencing? WebEx, Skype,
it is primarily WebEx right now, but there is some use of Skype also. We're in the process of changing or updating our tool. A little bit of both right now. One thing we've started recently, and this is done for interviews that use a certain form to sign up. It's called our applicant-initiated request form, and our application interview request form. Sorry. And if you use that form to sign up, what we end up doing after the interview is sending a survey to the examiner and to the attorney who interviewed the case. And that's so we can get some feedback ranging from anything about the interview itself to the technological connection that took place, to the assistance you got setting up WebEx or Skype. So it's really, I think, a very helpful step. We just recently started that, and I hope to be able to expand that.
So you can specifically request a video interview. That's great.
You can. So one of the benefits that we have at the office, if you use the form that I was talking about, and you can find this right on our website, but if you use that, we will know what type of interview you requested. When you do that, it goes to the examiner. The examiner will get back to you within 2 days. But we know, the timing of the interview. We know what type was requested, and we know what interview took place. We've often heard from some that I wanted a video conferencing, my examiner didn't want to do that. This is a good way for us to help keep tabs on is that occurring or not. The form is also an automatic agreement to use internet authorization for back and forth for setting up the interview, and I think that's helpful. And then again, it triggers a survey as well after the interview.
Cool. That's great with the video interviews. We've found the interviews to be very helpful. They save time and money, and you get a better result. And it must make life easier for the examiner too. It must save them work. I mean, I'm thinking it saves them work.
I think so too. It does.
If they can cut out a couple of office action cycles,
right?
Great for them.
Yep.
But as there's more hoteling, we've had a harder time doing face-to-face. As the video thing is great. We'll try it. We'll do it. I think that's great. I would like to get my clients to video more.
There's some, we have some videos on our website of the video conferencing capability.
Yeah.
And they're really helpful. They really show you what you can do. So videos to tell you about video.
Now with WebEx, you can do like video conference calls, right?
Yeah,
From different 3 to 4 to multiple locations.
Absolutely.
You don't have to be in 2 sites.
Correct.
Just like you, yeah. So I don't know if Skype is there yet, but that's good. I think Skype can do audio.
I think you can, right? So I have routine interviews, not interviews, but discussions with examiners, meetings with examiners. Well, I'll have 10 people in the room and 10 people on the web, and I've got 10 different connections. They're all located in different parts of the country, and extremely productive.
In WebEx?
All in WebEx.
Cool. Great. No time delay.
Once you get over the hurdle of learning how to set it up, it's very easy.
Yeah, it's a little.
There's a learning curve.
Yeah. Well, you get a more complicated result, so you got to have a more complicated interface, right? That's good. Okay, another question here. Oh, this is an interesting question. Kind of long. Some surveys indicate that about 15% of examiners issue about 80% of all patents, and that these examiners tend to be primaries. And about 80% of examiners issue close to 0 patents per year. This may be an exaggeration. And that these examiners tend to be assistant examiners without signature authority. If an application is assigned to a junior examiner with no signature authority with an allowance rate close to 0 in single digits, how may the applicant appeal this and get a new examination with a primary with a material allowance rate closer to the average?
Well, there's a lot in that question.
I
started to write down some of the numbers, and so I don't think I have them all, but I will. Those numbers are way off base. So I think you referred to a study. If whoever asked the question wants to send me the study, I'd be happy to have people take a look at that study. But I will tell you, and again, I don't know the exact numbers of the question, but there is no way that 15% of the examiners are issuing 80% of the cases. As I said, we overall have an allowance rate of about just over 50%. There is a range, of course, and that range is based on the particular technology that someone examines. I'm sure there's, low, like we said, in business methods, and even within business methods, there's ranges also, right? If you get towards, say, something that the Supreme Court has spoken on directly, you'll be less chance to much higher. We have about between 85 and 90% of our examiners have over a 25% allowance rate. So I can tell you that the numbers read off in the question are not entirely correct. It's a very, very small percentage of people who have the low allowance rates that are discussed in the question. Again, limited to the areas that are directly, implicated by a Supreme Court case holding something to be not patent eligible.
They're straight in the Alice.
Yeah, the question really raises the bigger issue about statistical use. And again, we use statistics at PTO, so I'm not going to say statistics aren't helpful and shouldn't be used. But I would be very careful having statistics about a particular examiner or even art unit, because I've seen them when they're accurate, but I've seen them when they're way off base. When people started to use that, I actually was involved in some calls with bloggers and people who wrote about allowance rates to explain why what they had was not accurate. And again, I'm not saying they're all not accurate. Sometimes they are, and sometimes we've seen that they're not. One example is I saw something written about an examiner who stopped allowing one day. This is the allegation that all of a sudden something went wrong with them and they just decided they're not going to allow. Well, what happened is they've changed jobs, right? So they weren't an examiner anymore. And so it's things like that there's sometimes explanations behind changes. But regardless, what's behind the question, I feel comfortable in saying primaries probably have a slightly higher allowance rate than juniors. I think primaries have more freedom. I think as a junior examiner, this is something we've been aware of forever, that it's a challenging job, and as they're learning, we know there's a slight difference. So we're always trying to be cognizant of that, but there's much more consistency across the office than in the premise of the question.
Sure. Yeah, it's an extremely challenging job. It definitely, as I recall, I think it was the first Supreme Court patent case said something about how writing a claim in a patent is the toughest job a lawyer would ever have, because you're trying to define the boundaries of intangible property, and you can't just send a surveyor out and measure it.
I think it's
true.
So what we all do, right? We're all in this together. Right. What we all do is incredibly rewarding, right? Going back to the brilliant inventors and the brilliance of invention, it's just fantastic, what we can accomplish in patent law and what those great inventors have done for society. That being said, an attorney's job of drafting a claim and an examiner's job of evaluating a claim are very challenging and very critical, because if you don't get it right, you don't allow something that should have, or you allow something that shouldn't have, or or the scope is not what somebody was entitled to. These are all problems we want to avoid. So it's finding the Goldilocks approach of getting it right, and that gets right back to what we can do at USPTO to reevaluate our training and our focus.
Yeah. We found in looking at some of the studies, I have no idea how accurate they are, but one thing we found was that it's hard to be, they're not comparable, because the way they calculate allowance rate, it seems intuitively simple, but in fact, when you got to deal with the numbers, and it's complicated. Specifically, how do you deal with parents, continuations, CIPs, divisionals, RCEs, different serial numbers. How these are counted is there's no intuitively obvious correct one way to do it, so everybody does it a different way. And a lot of times the studies are kind of vague about just what they did. And so in the end, you really don't know. It's difficult to know exactly what they're counting. And it's just, I think it's inherent in the complicated procedure of a family. I mean, is a family one application or what? There's one specification and maybe half a dozen patents. Well, and it makes, I don't know if there's ever going to be a good answer to that. But but it's a very interesting question. Everyone wants to know.
Yeah, we have seen studies that we agree with the analysis, and albeit their numbers are different from ours because they did it in a different way. So we think the numbers were accurate. They just calculated something differently from what we do. So,
right.
And again, that just creates.
Right. Inevitable. Another question. We have a few more minutes. You touched on this earlier. How many examiners are there? 8,200. How many are assistant examiners with no signature authority? How many are primaries? And how many art units are there?
All right. So let's see. I'm making a note here.
When in doubt, count. Right.
There are more than half are primary examiners. So out of the 8,200, you're probably around the 4,200 or more as primary examiners. So just more than half are primary examiners. And again, I don't know the exact numbers offhand, but that's I feel comfortable that's a very close number. By the way, the average experience of the examination corps is 10.7 years.
Really?
Yeah. We have 100 130 examiners who have more than 30 to 40 years of experience.
How many?
130.
Wow.
And then we even have, I've been told from a recent look, 2 examiners who have over 50 years of experience as examiners, which is just a mind-boggling number. Getting back to the question, so it's 8,200 examiners. The other part of the question, I'm sorry, I'm not remembering quite, I think was the number of art units.
Yeah, how many art units?
There's well over 500 different art units that we have. Now that gets to be, some art units we have are the combination of different technologies with multiple supervisors, and some are smaller. But suffice it to say there's somewhere around 500 different technology art units that cases can go to, so you can see it very extensive. Is there anything, what else was in the question?
I think there's how many primaries, how many assistants?
Yeah,
I guess that's
right. So the flip side of it, either primary or a junior.
Yeah,
just under half for the junior examiners.
Boy, that's a lot of.
One of the things we're looking at is whether or not examiners have the correct amount of time to do their job. The average examiner, and this is an average, and there's people way on either side of this, so please keep that in mind, but the average time for an examiner from start to finish of a case is just over 22 hours. And again, they range up into the low 30s to in the mid-teens, I think. So we are taking a look to see if examiners have the right time and what, if anything, should be done there. And that's a big undertaking with 500 different technologies. Every technology has assigned to it a production time. So every examiner has when you have a case, you have a certain amount of time to do that case on average.
So you distinguish by technology.
We distinguish by technology. Right? And so it gets challenging because easier technologies, easier to understand technologies don't necessarily mean easier prosecution. Right? It could actually be harder prosecution. The searches could be longer. If it's a crowded area, crowded art, the changes will be smaller, so the searching can be more challenging, the prosecution more challenging. But this is something we are undertaking, which has I think big ramifications potentially. Right? If you change, I mean you can do the math yourself, right? But if everyone gets 22 hours, if you added an hour, it's about 4.5% change in processing power.
Wow. Yeah.
But it's important to get it right and to make sure people do have the right amount of time, and otherwise we're shortchanging our numbers.
Right. It's a great statistic. Another question here. Interesting. How many Track 1 applications were filed last fiscal year, 2017? Track 1.
Track 1 applications in 2017 were somewhere around the 9,000 range. We were just under 10,000, I believe, in 2016, and the number decreased a little bit. The irony is we have a cap of 10,000, and that was really, I will tell you, that was a number, it was just a guesstimate when the AIA was put into place, and we really peaked just under that number, and then last year went down slightly. We expected the decline as we're working off our inventory of cases and pendencies are getting shorter. We expected less people to use Track 1, so not much of a surprise for us. But right now the Track 1 cases are, or last year were around the 9,000 number. And I routinely hear, including today before we started the WebEx, positive feedback about the Track 1 speed with which we were able to examine. So it's about a 12-month time frame from the time you file all the way up to a final disposition, which is just fantastic.
Wow. If you need it, it's fabulous. For example, if you have an M&A deal or equity financing that's dependent on your patent position.
Right.
And you're waiting for the money for the patent. Yeah. It's fabulous.
And it's a good those that
it's cheap too.
Yeah.
But it's just not relevant for most cases, which is fine because you're letting the demand dictate where you put the resources to accelerate things. You're not accelerating something where who cares, right? We're gonna wait 2 years. Do you happen to have a feel off the top of your head? I didn't ask you for the statistics. What the average pendency is of non-track one or
Sure.
straight bulk?
So the
said it was going down.
It is going down significantly since the last 7 years or so. We're about, on average, 15 months to a first action and about 24 months for total prosecution. That number is decreasing. With the filing rate that I said was a little higher, 2 percentage points higher than what we expected. Again, we're hovering around 3%, and we expected it to be around 1 to be consistent with prior years. This is a problem I want to have because we want more filings, and it's because it's great that people are being inventive and using the patent system. So this is not a bad problem for America, but with the more filings that come in, the harder it is, of course, for us to maintain the pendencies. So that's the catch-22 with that particular issue. But again, about 15 months and then 2 years for total pendency. What we'd actually are starting to focus on more than in the past is patent term adjustment time frame. So if rather than saying let's have an average first action and an average total pendency, which has been at the PTO for 24 years, it's always been the measure. What I'd like to focus on, either in addition to or instead of those pendencies that I just mentioned, would be patent time adjustment time frames. So by statute, we have 14 months to do a first action, 4 months to work on an amendment. It's the 14-444-36, for those of you familiar with it. 36 would be the total issuance of a patent. That is what I'd like to focus on because I think that is what adds the most certainty into the system. That rather than have an average with some areas higher and lower, let's get the highest percentage we can within those patent term adjustments so we're not awarding patent term adjustments because of PTO delay.
Basically, you want to get the term adjustment to 0.
Correct. And I think, any right now with an average of 15, you could be somewhere that's hovering around 10 or 11. You could be somewhere in the, in the 17, 18 range. So if we're focused more on the aggregate number, I think that's also good.
Yeah. Well, I just anecdotally, it does seem like we're getting last few years less adjustments. We just get less term adjustments.
And as
they're coming down,
we're
not getting the hundreds of the hundreds.
So as our pendencies are coming down, that will be the effect. And right now, the challenging one of those numbers, right, the 14-444-36, is the first action in 14 months. As I said, our average is about 15 months. So obviously, we're missing a lot of the 14 months cases. And when we can get that lower, the rest seem to be much easier for us.
Great. Okay, a couple more questions here.
Sure.
And we'll wrap this up. Well, they're asking here, compared to 2017, how many track ones were in 2016? And the follow-up is, what percentage of the 2016s are now allowed, and what was the average time to issuance? I think they're going to the dependency of track one. How much bang do you get out of the buck?
So the track one pendency from the time of filing to issuance, or final, we call final disposition of a case, is just about a year. The goal, sorry if I get too weedy on this, the goal is a year from the time of the petition decision. So we're well within that. It's about 8 or 9 months from the petition decision, and then again a year overall. As far as the allowance rate, I know I hear anecdotally people feel there's a higher allowance rate, but I think it's I don't know offhand exactly. I think the last time I knew it was slightly higher than the regular, than the non-track one cases, which I think makes sense to me because I don't think they're being examined differently. They're certainly not examined differently, different standards. It's all the same standard, but these are cases that people have identified as being extra important. So I think the prosecution is more focused on as they come into the office.
The we get that subjective impression, not measurable, but it's like people are just on more. And it's true for the applicant, too.
Well, if you're going to pay extra and you're going to expedite, I want to.
Yeah. Everybody just like to add an extra cup of coffee. Okay. One other question here, which came in later. I think this was in response.
I'm looking to see if I have the exact allowance rate, but I don't know if I do. Track one. But anyway, I can listen to your question as I peek over these stats.
I didn't mean to pop a statistics question.
No, that's okay.
I know there's so many of them, you can't be expected to walk around with your head all the time. This came in, this is an interesting question. I think this was reacting to one of the reports this week that so much was happening in patents. Is the PTO considering changes in quality measures? You begin to touch on this. Does the commissioner think that hard data such as reversals at the board should be used as part of these quality statistics? Kind of got into some.
We did. We got into some of that, right? We got into the board decisions, whether they're the AIA trials or ex parte trials. Again, I want to reiterate that, but there's a much bigger part to the question. We do believe that what the board does should be looked at and should be evaluated, and we are doing that. Again, there's differing levels as to how useful some of that is, because laws could have changed in the time frame, and it's a small subset for any particular examiner, but we do look at that for any teaching points. What we also do, though, is have very extensive quality review and quality metrics, and we can speak for the next few hours on that. We have a separate staff that does random reviews of cases in process. They historically have taken in process. So they'll take, right after a first office action from the examiner. Sometimes they'll take second actions. They'll take allowances, finals. We take a little bit of everything. What we're starting to do, and this is actually getting to part of the question, we're starting to do we're looking at whether we can take cases right after, say, an examiner's answer is written, because that would give us more real-time feedback from a quality review standpoint, and even waiting for the PTAB. PTAB will be helpful, but it'll be some delay when they get to the case. This would be evaluating it as it comes up to this, something we're considering. I won't get...
The examiner's answer for an appeal.
Yeah, an appeal brief. Yeah, right, exactly. Correct. And I don't want to get too weedy in this, but one of the areas that I've been really focused on in the last 2.5 years since I became commissioner is the way we evaluate quality, what the examiners do. Suffice it to say, in my opinion, we've historically done reviews that there wasn't a lot of reliability. Reliability is not the right word. The reviewers themselves would determine if prosecution was inhibited for an error or not. In other words, if they thought, well, what the examiner did wasn't entirely correct, but it didn't impact prosecution, they might say it was not an error. I'm trying to simplify that way down and just say we have statutes, and so our measure of correctness is statutory compliance. So we've really changed the way we review all applications on a per-claim basis. Is it consistent with the statutory determinations that we need to make? Yes or no, it doesn't matter if anybody believes it impacted or didn't impact prosecution, just that were you right in your decision-making or not. Doesn't sound like a significant change necessarily, but it's been changing a process that's been in place for decades and decades for thousands of examiners. We have revamped the way we do that. I think that's great. It puts us more in line of reviewing a case the way an attorney would look at an examiner's office action and say, okay, to an attorney, if you have to respond to a rejection, and that prosecution that you don't think is right, then that prosecution has been impeded. And so we want it to be more consistent with the way the public looks at cases.
That's great. That's great. How have the examiners reacted?
I think fine. I mean, obviously any change is change and can be difficult. And I think just I think people get it, they understand it. It makes sense. We have statutes, and we just need to evaluate are correct or not under the statute. And it's more nuanced than that, though, right? I mean, there's where we get into some questions is, there's a certain notice function in the statutes, right? I mean, it's okay to make the right decision, but you have to convey that, and how much of the conveyance is considered proper or not proper, and that's where it gets a little challenging and gray. But I think we're working our way through those issues. I think it will be a much more productive approach than what we've done previously.
Great. I've received a message that we're out of time, so we got to get off the air. I want to thank you for coming out.
Thank you very much.
It's been very interesting. And you're continuing the great patent office tradition of being totally open and candid and transparent, which I think is a tremendous help to the whole patent community.
Thank you.
And it provides a great product for the public and helps us all together promote science and the useful arts. So thanks for coming out.
My
really
pleasure.
Appreciate it.
My pleasure.
Thank
you very much for having me.